Let's take a look at privacy issues in the public workplace. Conflicts arise when people feel that managers invade their private affairs or private workspaces. There are times when invisible privacy barriers may be breached unconsciously in the regular course of business, such as when a supervisor calls a subordinate at home or searches her desk for an urgently needed work document. The Fourth Amendment, which limits government ability to conduct unreasonable searches and seizures, is the main restriction on workplace searches by government employers. In the leading case of O'Connor versus Ortega, 1987, the Supreme Court held that whether a search violates the Fourth Amendment depends on whether the area is one in which the employee has reasonable expectation of privacy and whether the search is reasonable under the circumstances. The court determined that Ortega, a physician, had a reasonable expectation of privacy in his desk and file cabinet because he was the only one who used the office. He stored only personal materials there, and his hospital employer had never discouraged him from keeping personal items at work. Next, the court asked whether the search was reasonable under circumstances. A reasonable search must balance the governmental interest in efficient and proper operation of the workplace with the employee's privacy interests. It does not require an employer to obtain a warrant or even give an employee prior notice. Managers may wish for a brighter line, but the reasonableness of an employee's privacy expectations and the reasonableness of a search are determined by the discrete facts of each situation. Agencies can take steps to increase the likelihood of searches being lawful. They can reduce expectations of privacy by eliminating personal workspaces and adopting policies authorizing searches. Most employers have policies allowing searches of employees' texts, emails, and internet use on the employer's devices and networks. As a result, employees have no expectation of privacy in these domains, and searches are permissible. Agencies also may conduct video and telephone surveillance if these policies are communicated in advance. In sum, there are few restrictions on the rights of organizations to monitor personnel at work, especially if employees are told about their lack of privacy up front.